President Cyril Ramaphosa succeeding in his urgent interdict to halt the proceedings of the Impeachment Committee pending his full review of the Section 89 report. We're currently getting a number of political parties reacting to that. Also just spoken to a legal analyst indicating that where it stands now, that urgent interdict cannot be appealed, but most certainly everybody looking to study just the reasons of that judgment that was split three ways, Ayanda.
It was indeed, and we're still awaiting the reasons for that judgment. But let's take you straight to the steps of the Western Cape High Court. Once again, that's where we find SABC News anchor Oliver Dixon, who's been watching the build-up, the ruling itself, and now the reaction. And Oliver, I imagine a lot of political parties are making their voices heard there, especially when you consider the work that they put in to get us here.
Yeah, Ayanda, the ATM was a respondent in this interim interdict application. They're also a respondent in the substantive review that's before the review court to be heard in early September. I've got with me Vuyile Tuzungula, who is a respondent twice in his first right as himself, Vuyile Tuzungula, Member of Parliament, and also as a representative of the ATM. Vuyile, when we spoke earlier, this is not the result you anticipated. What now?
We are going to read the judgment, find out exactly what have they stopped. Is it the entire process or the hearings aspect of the process? Like, can we continue nominating or deciding the evidence leaders, terms of reference, having the independent panel come, table the report? What exactly has been stopped? We're going to find out once we read the judgment.
And that's an important part, because my reading into the words that was used by the presiding judge was that the committee is precluded from a public impeachment hearing. So it seems as though the administrative work may still well continue. And of course, there is that deadline that exists today for parties to make their final submissions on that. Does this in any way, this judgment, change your approach to how you'll be going forward in terms of your work in the impeachment committee?
The judgment, once we read it, we're going to have a full understanding. However, today we're going to continue submitting our names, and we're expecting that next Wednesday we're going to decide and agree on the terms of reference. However, what becomes very tricky now, without reading the judgment, of course, is that can we proceed with the questions of having the other aspects of the preparations in terms of getting the independent panel coming to table the report, getting some aspects, or is it a case whereby the president himself cannot come to the witness stand, but the other people that the committee would want to get evidence from can actually come? So we're going to wait, read the report, but consult our lawyers so that we push this question of accountability, because the reason why we are here is that there is misconduct on the side of the president, which has been affirmed or confirmed by independent panel of experts, and it would be failing South Africans as members of parliament if we don't get evidence, we don't get the truth and answers when it comes to having an inquiry.
Yeah. You also have to focus on the review application, where you are respondent as well, and that is to be heard in September. Re-encapsulate for us the arguments that you're making there.
Look, when it comes to a review, the main argument we are making is that for a review to actually succeed, there needs for the president to be able to set aside that report. He needs to make it a point to the court that, firstly, there's culpability that has been determined. And this report is not saying anything else besides saying there is a case to answer, therefore proceed with an inquiry. Now, to have a case now in which an inquiry, because the guilt, Oliver, of the president has not been determined, his rights have not been infringed. The only thing that the independent panel found is that there is enough evidence that suggests that an inquiry must be held. An inquiry can have two outcomes. One, the president is guilty, or the president is innocent. Therefore, you can't then stop a process of accountability, stop a process in which South Africans were going to get the truth, going to get the facts as to what transpired.
Yeah. To the question of evidence, and prima facie is the level that was met by the Nobo report. However, the president makes the argument that it must reach a level of sufficient evidence. And of course, you know that there was a limitation in terms of how much work the Nobo panel could do in terms of evidence gathering and calling witnesses to appear before it. And so the president then says because of that, they also then misdirected themselves in what they thought they needed to do. What's your view on that question of misdirection?
There was no misdirection. If we can remind the viewers, 2017 December, the Constitutional Court says there must be rules to give effect to an impeachment process. And that was, the order was given in December 2017. What then Parliament did immediately after was to have those rules as instructed by the Constitutional Court. So when this issue came to Parliament in 2022, the independent panel, the Nobo panel, actually complied with the rules that were drafted even by the Constitutional Court. So that is why you are here. It's not like Parliament, out of its own violation, decided to have these rules. There was no misdirection because what the independent panel were supposed to ascertain whether the motion that is before them and the evidence before them, is there a sufficient case to go to a full inquiry? And the answer was yes. And the side of the president was actually taken because there was a motion that we provided, there was the additional evidence that we provided. All of that was placed before the president. The president responded to everything, including his head of security, Wali Rode, gave evidence. Now, in the light of both information, both from us as a party who submitted the motion and the responses by the president, the independent panel said, taking into account all of this information, there's a case to answer. Parliament must hold an inquiry.
And just lastly, one of the arguments that the president made is one of the 4 points he had to, pass as a prerequisite to get this interim interdict passed was that there was no alternative remedy. That is to say that he engaged, and he made the argument that he engaged Parliament and the committee on his timeline and timetable and these sorts of things, and they didn't want to hear him out on that. So he had no choice but to come to court. Do you think in retrospect, so ostensibly he won the matter, that means that he ostensibly won the consideration on alternative remedy. Do you think in retrospect that the committee should have met with the president, or Parliament should have met with the president and discussed a timeline on the way forward, given that it was almost inevitable that the president was going to take this on review?
No, Parliament must do its work, hold whoever is an executive president accountable. It cannot discuss timelines or the methods in which it can hold him accountable. That is why if any person is unhappy with the parliament processes, they can easily approach the courts like they've done now. But we would never have agreed to a way forward in which allows then the president to somewhat discuss or engage the committee as to how the committee can do its work. And even today, when we submit our names, we are going to be very clear that we must have a process that is all about Parliament independently doing its work without any form of undue influence from the president or anyone, including some people that would have wanted to delay and frustrate the process.
And just lastly, one of the arguments that Anton Katz made on your behalf on this matter, and it also reflects in your papers, is that it might inconvenience Parliament more than what the court was willing to accept, given that if it pushes this to September and the review court hears its application in September, and let's say a judgment comes out a month or 2 or 3 after that, by the time a judgment comes out, it's time for the local government elections, and that pushes out the parliamentary calendar altogether. So this might only begin to find momentum in 2027, which is itself a contentious year, given that the ANC then approaches its elective conference, and that might change the entire atmosphere of the body politic of the country altogether. Do you hold on to that given the outcome today?
Yeah, look, this issue has been in the public domain since 2022. As we are speaking here now, there's no South African that can confidently say we have gotten all of the answers when it comes to Phala Phala. And therefore, to have another form of a delay in the sense that this interdict is basically delaying Parliament or delaying South Africans from receiving answers as to is there misconduct on their president. I think this court made an error and undermined the constitutional obligation of a parliament that is representing the people, because it is not me and the other members of parliament who just want answers. It is South Africans. And we do not want answers on Mr. Ramaphosa's private affairs. We want answers in terms of his public affairs that affect me and you as South African citizens. So to have a court today delaying that, in addition to the other delays that we've had since 2022, this judgment, it is something that South Africans should be really worried about, whether the court today really is for the people or the court here has made some political considerations and maybe ruled in the favor of the president instead of affirming the constitutional provision of accountability and having a parliament that is a voice of the people, providing a platform for South Africans to get answers from the executive through their elected representatives.
Violet, thank you so much for that. Really do appreciate it. Violet Zungula is a representative of the African Transformation Movement, a respondent in this matter, and a member of the Parliamentary Impeachment Committee.